First order of business is roll call.
Good afternoon. Priya Mathur.
Hello, good afternoon.
Dana Hollinger.
Good afternoon.
Margaret Brown.
Here.
Matthew Saha for John Chung.
Here.
Rob Fechner. Ramon Rabucava.
Here.
Teresa Taylor.
We do have a quorum, and please note for the record also that Mr. Jones, Mr. Slayton, Mr. LaFaso, and, oh my gosh, Ralph, Cobb, I'm so sorry, and Mr. Cobb are also,
Mr. Ralph.
are also in attendance, forgive me. I know, I just had a moment. And Mr. Miller, because he's all the way on that side. Sorry, thank you, are also all in attendance. So that's terrific. Okay, now agenda item number 2 is approval of the September 24th, 2018 Board Governance Committee timed agenda.
Motion to approve.
Motion made by Hollinger to approve, seconded by Taylor. Any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Any opposed? Motion passes. Agenda item number 3 is the executive report. Mr. Jacobs.
Good afternoon, President Mather and board members. A very short executive report here today. I just wanted to alert the committee to something I'm sure you already know, which is that the only substantive item on the agenda today is a second reading of the proposed policy on the handling of harassment allegations against board members.
All right, thank you. Any discussion on that? Seeing none. On agenda item number 4, approval of the August 14th, 2018 Board Governance Committee meeting minutes. Moved by Mr. Fechner, seconded by Ms. Taylor. Any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes. That brings us to agenda item 5, the information consent items, and I've had no request to pull anything off of consent. And so that brings us to agenda item number 6, the process for handling harassment allegations against board members, second reading. Mr. Jacobs.
Yes, thank you. So this is coming back for, as you said, a second reading. The history of the development, the request from the committee for this policy is laid out in the agenda item. We brought this forward in August based on the with a draft policy that was based on the UC Regents policy with respect to the same topic. And there was a lively discussion about various issues in the draft policy. And we were asked to return with a new revised policy that addresses those points, comments, and concerns. And that's what we've endeavored to do. As the agenda item lays out, there are some choices in here for the committee and ultimately the board to make about various aspects of the policy. But I will just highlight a few of the changes that we made based on the discussion in the August session. And those are that, first, instead of automatically making the 2-member review panel, that is the 2 members of the board who would be members of the review panel to work with the investigator, instead of making those automatically the president and the vice president of the board, the new draft allocates that responsibility or the responsibility to the president to appoint whoever the 2 members would be. Second, instead of the general counsel being involved in or having a role in the investigation, the review panel would work with an outside non-CalPERS investigator. Thirdly, the general counsel would not have any role in recommending what the sanction would be. That would be up to the committee and ultimately, well, actually it would be to the board in the first instance. The list of potential sanctions has been changed to mirror the language that already exists in the board governance policy with respect to a violation of that policy. And there are some other changes as well, but those I would characterize as the most significant ones. I would make a overarching comment, which is this is not an exhaustive or comprehensive code that covers all the potential scenarios and procedures that might be applicable to a particular situation involving an allegation of harassment against a board member. This is what I would call the basic building blocks of a procedure that may have to be further developed as we confront particular issues, or we would fall back on existing law. By contrast, if we were trying to cover absolutely everything that might come up, the Code of Civil Procedure, which covers just about everything that could come up in a civil case, covers about 18 volumes of the West's annotated codes with both the code sections and then the annotations. So there's a lot of law there. And so that's not, just to be clear, it's not what we're endeavoring to do here. This represents some fundamental, basic and fair procedures that would apply to a good number of potential scenarios and get us started, but it doesn't cover, to be sure, everything that could arise in the investigation. And as I say, for that, we would have to develop it, the board would have to develop those, or probably fall back on existing law, because there is quite a bit of existing law in analogous situations. So those are my thoughts, and I give it back to you, President Mather, for a discussion amongst the committee about what they like and what they don't like about this new draft.
Thank you very much. I'll call on Ms. Taylor.
Oh, thank you. I was first. So I'm looking at attachment 3, which is the underlined crossout.
Yes.
And so a couple of things. First, on page 2, I think that's page 2. Yeah, page 2 of 5. I want to clarify, after it has been appointed, the review panel shall appoint an investigator who may not be a CalPERS employee, comma, to conduct a preliminary confidential investigation. So what's the point of having a review panel if you're just appointing an investigator? So why wouldn't we just have, that's my first question, why wouldn't we just have the president pick the investigator? I don't see that it's necessary for us. We either have a review panel to conduct the preliminary investigation and then assign it out, or if we are not going to have the preliminary investigation done by the review panel on the board, then I would assume that we don't need this extra step, is my thinking. You guys may not agree, so that's fine. Second, on the second to last paragraph on the page, you have the investigator shall, and you have consulting, and you need to cross out, I don't know if you did or not, it doesn't look like you did. ing, just grammar. That was a grammar issue.
Ah, very good, yes.
And then, where'd it go? There it is. On page 4 of 5, and this I leave up to the committee, but I think, let's see, sanctions that may be imposed, it's types of sanctions, number 4, on a board member include but are not limited to admonishment, formal censure, temporary termination of a board member's travel privileges, or the requirement of additional training. More than one sanction may be provided. So where we cross, so that's the underlined part. That's the new stuff. What we crossed out, it looks like are as follows: formal censure. Oh, okay, it's still in there. Removal or suspension from a committee assignment, revocation of board privileges, and or recusal from certain board proceedings or decisions. So I have concerns that we are lessening it to just taking away their travel privileges of board members. This is a pretty serious, if they're found guilty of sexual harassment, that's a pretty serious allegation. This has occurred before, and I think that I don't know that I would want someone who's been found guilty of that to be serving on board governance, nor should they be serving on our hiring committees. So that is my feeling. So that would be our performance compensation and talent management. I think that if they're going to perform their fiduciary duty, they can remain on investments and finance administration, risk and audit, any committees that have to do with their fiduciary duty, but any committees that have to do with governance of our board and or hiring of other people, they should not be on, is my feeling. I don't know how the rest of the committee feels. So I will take, if somebody wants me to make a motion on that, I would be happy to make a motion. And then lastly, let me make sure I found this right. Hold on. I don't know the difference between revocation of board member privileges and I guess, yeah, so what are board member privileges, Mr. Jacobs? I'm not sure what that is and why we cross that out.
The idea really was just to be consistent with the language in the board governance policy. So revocation of board member privileges, in fact, I think I wrote this in the agenda item, is broader. I'm not sure exactly what it applies to, but it's certainly broader than the language about travel privileges.
And the travel privileges are what's in other?
That's in the board governance policy. This is the exact language that is in the board governance policy with respect to the sanctions that can be imposed on a finding that a board member violated the board governance policy.
So
This
is outside of the board governance policy. This is a sexual harassment policy.
Correct.
Okay. And again, I would be happy to make, I don't know what that means either, so maybe I'll just leave that alone. I don't know what board member privileges are. Does that mean not going to not using the board rooms back here? Is that board member privileges?
That's a question, I think, for the committee to discuss. What are the so-called board member privileges? I think I had a discussion with Ms. Brown about that last time. I think that it could be, it really couldn't be access to your resources to carry out your jobs, but it might be access to the meals or
well, our resources in the back, all our resources are available right here. So we don't necessarily, I never come here.
Yeah, I meant more like your offices or
Yeah,
your,
I never come here, and I live in Sacramento.
right.
So I don't know that it's necessary to have access to the back rooms on off-board weeks. So that could be board privileges, but anyway.
I think the point is not necessarily to have this be an exhaustive list that covers all possible sanctions, and so maybe the board member privileges was a little broad, and that's why it was removed specifically, but yeah.
That's fine.
Yeah,
I
the
think
thought was really,
just
look-
saying
But-
travel is a little bit,
Yeah, but we could add back in the committee, removal or suspension from a committee assignment, which I know we had some discussion about last time, but is, no board member sits on every committee. It's not necessarily necessary to execute your fiduciary duty to sit on a committee. And also, committee leadership assignments might also be another thing that could be.
there you go.
So
There you
we
go.
could add those two back in. And that might be my suggestion.
I would like to make a motion to add back in, let me read it so that I get it right.
The removal or suspension from a
Removal
committee
or
assignment?
suspension from a committee assignment. And that was it, right?
And would you also add in removal or suspension of committee leadership positions?
Yeah. We don't have that there, so yeah.
Okay.
I would second,
You're seconding?
I would second.
Terrific.
that
Okay,
motion.
motion made by, so the motion, Ms. Taylor, was that to adopt the process as laid out with that change that you've articulated? With the change of adding back in
The removal.
the removal or suspension from
Suspension of
committee
assignment and removal or suspension of leadership. And also the corrections I said.
And also the corrections you
Yeah.
earlier said. So that's the motion.
Okay.
And seconded by Hollinger. Thank you for that clarification. Mr. Slayton?
Thank you. I would agree with adding those back in. Although we say include but not limited to, it makes it difficult to impose something that's outside the boundaries of this if it's fairly significant. So I think those two are good. The committee assignment, leadership roles. And I would suggest, I would ask if the maker of the motion and the second would accept a friendly amendment of adding back in the revocation of board member privileges. And the reason is, let me give you an example that I think would fall in that category that might be appropriate, is representing CalPERS, speaking at a public event representing CalPERS. That might be something we would want to, and it might be not require any travel to do it.
Right.
So I would suggest that leaving that broader language in gives just a little more teeth and flexibility to come up with an appropriate sanction given what the offense might end up being.
Is
So-
that acceptable to the maker
Well,
and
I'm
seconder?
I'm not a committee member, so.
We've got three things then. So we want the suspension, removal or suspension from committee assignment, removal or suspension from a leadership role on committees, and revocation of board member privileges to be added back in addition to the
In
corrections.
addition to the technical question, correction.
Could I
Yes,
make one
and
more?
just confirming that's acceptable to the seconder. Okay.
Okay. Now, the next one, which is maybe a little more difficult, which is recusal from certain board member proceedings or decisions. And let me make a comment about this of why I think some version of that should go back in. Let me paint a little picture for you. So there's an accusation of harassment, and the process finds that it's accurate. So now we face a situation where the person is the person who is guilty of that, or found, not in a court of law, but found by this process to have done it. So the perpetrator is sitting here as doesn't even have to be a committee member, but sitting at a meeting, and the person who has been harmed is an employee of CalPERS and required to be presenting at the meeting and has to deal with the interaction from a person sitting at the dais. And so I would say that what's the value here of, quote, fiduciary duty of attendance or the protection of someone who has suffered from this activity. So I just raise that as a conflict, that if you don't have the ability to say you can't be in that proceeding, you don't have an ability to necessarily protect the other person. So I just toss that bomb into the middle of the auditorium and see how people feel.
Matt, do you have any response to that comment?
It's a tricky issue. You've got your fiduciary duty to ask questions and to participate in the board proceedings, weighed against entirely legitimate concern that to use the term in the scenario, victim, not be further hurt, traumatized, whatever. I'd have to reflect on it further, and I think it would depend upon the particular situation, which is a typical lawyer answer, but I would say that the fiduciary duty is probably going to trump. But again, it would be kind of a scenario by scenario inquiry.
So the alternative is it could be, that interaction could be controlled and monitored by whoever's chairing the meeting and
Correct.
counsel
Correct.
to make sure that it doesn't get sideways.
Correct.
Yeah.
That would be a less intrusive alternative in legalese, which is usually preferred.
So perhaps we don't need to anticipate that necessarily in the
Okay.
process, but handle it in the moment.
I think that's right.
Yeah, okay. Mr. Fechner.
Thank you, Madam Chair. First off, on the same paragraph that Teresa started on page 205, as I put my finger on it, it moves. That first paragraph, after it's been appointed, the review panel shall appoint an investigator, comma, who may not, that may should be changed either shall or must.
Who
Well, it says
shall not be a
said may
CalPERS.
not be a CalPERS employees, which it could imply they could be, and we said they couldn't. So we need to change that to either shall or must not.
Are you comfortable with that, Mr.?
Oh, yeah, that's
Jacoby?
fine. That's the intent.
So is that accepted by the maker and the seconder of the motion?
Absolutely.
Okay,
That's another technical.
yeah. Anything else, Mr.?
I have something else to say, but it's not on the motion, so.
Okay, so can we come back
Sure.
to you? Okay, thank you. Ms. Brown?
Thank you. I have something at a little higher level. So, when I read the item under background and analysis, we talk about how in March of 2018, we explicitly applied the harassment policy to the board. But when you read that policy, it talks about the roles of employees and managers and supervisors, but it doesn't talk about the role of the board. And if you go through that document, it talks about it throughout that document, but it nowhere references what board members are supposed to do. And so I have concerns about that, because are we managers and supervisors? I know we're not employees, but if that applies to us, we're nowhere mentioned in that document at all. And I think that should be addressed if we're going to be governed by that document.
Okay, well,
I mean, because it starts out that purpose, CalPERS expects its managers and supervisors to vigorously and visibly promote a harassment-free. I mean, I think you could very easily say the board manager. I mean, I just think it needs to be modified, in my opinion.
yeah. Yeah, I think the idea, and when the board voted last year to adopt the harassment policy for itself, I think it implicitly substituted board members for those words like employees and the like, and said we will be governed by, that is the board that said it, we will be governed by the harassment policy that applies to team members. There are parts of this that would not apply to board members, to be sure, and I think that where there's a conflict, or where that's what we're doing here in this process, is providing a process that would trump anything in here that would relate to a board member with respect to the process by which it would occur. Because in an employee context, you've got an entire process. It's overseen by the SPB and other laws and the like, and internal policies. And many of those are not going to apply to board members just under the law. So what you've got here is the outline of a policy to address those kinds of harassment allegations as to board members.
My concern is that if it gets to an independent council, an implicit policy isn't going to help us help if it's not explicit, in my opinion. And you'll find out the first time it's tested. I don't know how long it would take to modify that so that it does include the board.
I think we adopted it in March
March of 2018, right?
of 2018. So perhaps all it requires is a sentence that says in all cases where the word staff is used, that applies to board members. And maybe we could even put that in this,
Sure.
in this policy and just say, in reference to that policy.
Yeah, that's a good idea, because it says right here at the opening that the policy sets forth procedures to be followed when an allegation is made that a member of the board has violated the CalPERS harassment, discrimination, retaliation prevention policy. And then further on, it says the policy relies upon and incorporates the harassment prevention policy as a foundational document. And so right there would be a place to indicate that we substitute the word board member for employee or what have you in the
Yeah.
following places.
Yeah. So so I think we should, is that something that you think we could just add today, a sentence that accomplishes that?
I do, but what I would suggest is if this motion is adopted, that I bring back, since there's been a few different suggestions, and it may sound like everybody's on board today, but when it's actually written out, it may look a little bit different to some people, so that I would put it, bring it back with the changes that as best we can make them from the transcript, and put it on the consent calendar. And then if somebody disagrees with what we've done, somebody can pull it off the consent and we can talk about wordsmithing a particular concept.
Okay. Or perhaps, I don't know if it's possible, I know it's Monday today, but is it something that could be done for
Oh.
Wednesday for the board
Oh,
meeting?
That's an idea. Yeah,
Okay.
sure. Yeah.
So the maker and seconder of the motion, are you comfortable with adding that language into your motion?
Yes.
Okay. Thank you. Okay, Mr. Seha.
Thank you, Madam Chair. I had the benefit of talking with Matt a little bit about this item previously, and I was hoping, Matt, you could talk a little bit more, maybe for the benefit of the other committee members, on the possibility of including some NDA language, and if you think that there's a need for including that in scenarios that might call for it.
Non-disclosure agreement.
Yes. Thank you.
Yes, well, the policy does state in several different places that the efforts, the investigative efforts will be conducted and the results thereof will be maintained confidentially to the maximum extent permitted by law. So that's kind of one of those examples where we're falling back on existing law. I think what you're talking about is the possibility of there being a resolution
Correct.
of some kind of allegation of harassment. And at page 3, under section E, board action, it does provide that the possibility of an informal resolution. And that informal resolution could take a lot of different forms, from a stern oral directive to something more substantive. I don't know that it would ever end up in some kind of a formal written agreement because the extremes, I mean, there's basically 3 scenarios that could come out of an investigation. One would be nothing, because either the preliminary investigation, either the review panel and the investigator determined there was nothing to see here, or it was shut down after the preliminary investigation, or there wasn't enough to make a finding, in which case it would also be shut down, or there'd be a finding and then it would go to the board for a determination of a sanction. But you're right, it could be some kind of resolution in between, and I think, again, that would be one of those situations where we would just have to rely and fall back on existing law, which would generally be, with respect to a board member, it would probably be that it's not, that an NDA would not be appropriate. In fact, NDAs are generally not appropriate, except sometimes with respect to personnel matters. So I don't know if that answered your question. I kind of rambled, but
No, that's good. Thank
Okay.
you. And yeah, I just wanted to piggyback on that really quickly, if I may, just to ask about the settlement process with regards to any civil litigation that might be included in the policy, if you think that that would be something that would be beneficial as well.
Yeah, again, my comment on that would be, this is kind of the bare bones,
Right.
and we can certainly add something like that. I don't think it's necessary because it already talks about there being the potential for an informal resolution. And if we start cataloging all the different ways that could be resolved, I'm going to come back with a 10-page document. I think that's something for further development if and when it comes up. That would be my take on it.
Okay. Thank you very much.
Thank you. Mr. Jones?
Yeah, thank you, Madam Chair. Yeah, my comment goes to item number 3. Just a minute. Procedures for investigation of allegations and imposition of sanctions. In that section, it makes reference to the board president and the board vice president about their role in establishing the investigative process. And there needs to be something to cover the fact that it says if the board president and vice president are both subject to the allegations, otherwise who cannot serve, the matter shall be referred to the board governance committee. And our current structure and the proposed structure could include the president and the board president. So I think you need to add something that says that excludes the president and the vice president, because it is a 7-member committee, so it could drop to 5 and you still would have a quorum.
I see. So what you are suggesting is that the matter shall be referred to the board governance committee.
Excluding the president and the vice president.
Yeah, in that case.
Yes.
That's fair.
Yeah.
That seems appropriate. Thank you for that comment. I see that it's accepted by the maker and seconder of the motion as that is. Thank you, Mr. Jones. Mr. Miller.
This is kind of a clarifying question from my perspective. You had indicated, Matt, that this was intended for sexual harassment. And I'm wondering why we don't have the word in there, and whether, because, what is the definition? Is it the Webster Dictionary definition? Is it the California definition for civil harassment, which is very, very different? Or is that made moot if we include the line that refers back to the CalPERS policy?
It is made moot, and the reason, Mr. Miller, is that the reference back, it's not just sexual harassment, it's harassment. Okay. And the policy that is attachment 2 says attachment 2. Attachment 1. Mm-hmm. It says attachment 2. It should be attachment 1. Does have definitions of harassment and sexual harassment.
So it was inclusive of sexual harassment,
yes.
Not exclusive to it. Okay,
yes.
Thank you. That was my confusion.
Yeah.
Thank you. Ms. Brown.
I'm done, thank you.
Oh, thank you, Ms. Brown. Okay, so we do have a motion on the floor, but we have several members of the public who wish to comment. I'll let them comment first. J.J. Jelinek and Ms. Jeppesen, if you could please come forward and take these 2 seats to my left. Identify yourself and your affiliation for the record. You'll each have 2 minutes to speak. 3 minutes, I'm sorry, 3 minutes to speak.
Chair's too high.
You're on.
I'm J.J. Jelinek, speaking for myself. I would not be here except for the footnote. I was the public presenter who said I had not seen the policy being cited. I said that I did not recall seeing the policy. It is now asserted that copies were given to all board members in 2017. That type of casual misrepresentation is unfortunately fairly typical of the Chief Counsel. Most people in this room and most people watching on the internet know that I had a habit of reading all the material given to the board. I had not seen this policy until I got it as a result of a Public Records Act request. It was available only on the intranet or by a PRA if you happen to know to ask for it. Since the policy is a management policy, adopted and modified at will by management, which did not apply to the board, there was no reason for the board to see the policy. Staff adopts policies and procedures all the time that the board never sees, nor in most cases needs to see. This policy is not broad enough to cover the chief counsel publicly dressing down the board's independent counsel for administrative hearings for failure to support the staff's position. This change to board policy is about controlling board members. That is why it is coming before this specially called committee meeting. It should be noted that a staff member accused of violating the policy would have the right to a public hearing at the SPB. However, a falsely accused board member would have no right to a public hearing. That board member would be dependent on a secret kangaroo court. I urge you to either reject the proposal or amend it so that the board members have a right to a public hearing and the opportunity to present a public defense. Thank you. And I have one other observation, not directly related to the policy, but Robert's Rules of Order makes a motion the property of the body, and it can only be changed by a vote of that body. It cannot be changed by the maker of the motion. Thank you.
Ms. Jeppesen.
Good afternoon. I have sat at the back of the room for many years. And when I look at this policy, which I lost it as we were going back, amending this, amending to the amendment, and I'm wondering if we just didn't treat this by having what we do, you know, I think that it should be totally removed from the board. I don't think it should be a review committee if there is a problem, because you may be sitting next to you and one may be quote, the victim, the other may be the perpetrator. And it seems to me that, you know, there are, in the state, we have things that you can do. You know, you can have like, you can have independent agencies that handle this, like the state has this. And I think rather than having the board involved, it gives the impression that you're out to get someone. And I don't think that's the case here. I think the board is a lot better than that. And so what I would do is where I could remove the board getting involved, because I just can't wait to see what the newspapers would come up with this one. Thank you.
Thank you very much. We have three more members of the public who wish to speak. Mr. Brennan and Ms. Bauma, you're next. If you could take these two seats to my left. Identify yourself and your affiliation for the record, and you'll have 3 minutes to speak.
Good afternoon, near good evening, Madam Chair, members. Terry Brennan on behalf of SEIU California, here in support of the policy. It has been amended a few times, or suggested amendments. I agreed with all of them. I think you need to take seriously Mr. Slayton's concern, because if we get in a situation where one of your team members has been victimized, we failed. As an organization, as a society, as an employer, we failed. If they're required to then present, testify, be in front of their victimizer, we failed again. Don't fail them twice. Thank you.
Thank you. Ms. Belmont.
Chair members, Christy Baum on behalf of the California Professional Firefighters. I come before you today with credentials on behalf of my organization to speak to you, but also as one of the signers of the We Said Enough letter last year. As the current president of the Institute of Governmental Advocates, who was invited into the legislature's process and discussion about how they were going to establish a harassment policy applicable to elected members of the Senate and the Assembly. And I'm an owner of my own small business with 4 whole employees, and have challenged myself to take a view of how these policies should apply to a broad organization like CalPERS with an elected board and little old lobbying firm with 3 or 4 employees. I think it's an issue that needs to be taken seriously across the spectrum. I know that this board is independent, and even in listening to the dialogue in the legislature, who they believe they were different, but finally came to terms with the fact that they need to do something that would embrace the public's confidence, that victims would have a forum on which to be protected, and perpetrators would be held to account for the way that they're treating their fellow human beings. So I'm here in support of the sexual harassment policy, and as it is evolving here, I appreciate the dialogue and the comments about how to improve the policy, but I think no need to waste another moment about making sure you have a clear policy directive for yourselves and for your dedicated staff members that serve you every day and every month. I think the final thing that I would say is don't forget about the training. The very valuable lessons that I've heard in being part of these discussions is make it an approachable training, small group training, bystander training. You know, it's very difficult for a victim on their own to find their voice and speak out against mistreatment of any kind, harassment of any kind. So train all of the team members, should be good bystanders to what could potentially be a sexual harassment or other type of harassment that's going on, and let them help improve the culture. So I appreciate the conversation. I appreciate that you're bringing this up and trying to get a policy adopted, and urge you to get that squared away. We're in support.
Thank you. We have one more member of the public who wishes to speak, Ms. Lee. If you could please come forward, take one of these seats to my left, identify yourself and your affiliation for the record, and you'll have 3 minutes to speak.
Hello, my name is Jackie Lee, and I'm a CTA liaison for CalPERS. I'm just looking at the policy. It says harassment, discrimination, and retaliation prevention policy. A lot of people keep referring it to sexual harassment, but I think it talks about all harassment.
It does.
So I'm just curious, why is there such a rush to get this finalized like right now? When there are so many questions posed by you members as well as questions that we have. I think that wordsmithing the document is always very needed when we're doing this. And I used to do tech writing for a computer firm, and so it was the Association for People Who Are computer people and users, and sometimes the two do not match. And I think sometimes this is what's happening in here, and it's a requirement to take more, to look at all the angles. I'm wondering, is there a reason why there's so much rush to do this? My suggestion is to carefully review all documents, and when all questions are answered properly and satisfactorily, then put it to a vote. Because it seems to me, the appearance, the rush is that there's a reason, because you have someone in mind to go ahead and sanction. And that doesn't make me feel good about the whole process. And I've been here for 5 years. I would like more clarity, more careful decisions that if it takes time, then it takes time. If we need to do it in December, then let's do it in December. There's no rush to do a good policy. Tech writing taught me that, and I would really like for this to be applied here, and that's my suggestion. Thank you so much for your time.
Thank you for your comments. So I think it would be useful to restate the motion, and perhaps if it's easier if it would satisfy Mr. Jelinczyk to withdraw and then re-enter the motion fully, which would be, I think, perfectly fine. Okay, so what, maybe I can take a crack and you can help me, Mr. Jacobs, to, at restating the motion, and then you can tell me if and then you can say, yes, I make that motion, if that's amenable to you. So the motion, as I understand it, is to adopt the policy with several modifications, including on page 1, section 3, procedures for investigation of allegations and imposition of sanctions. In the last sentence, after the words board governance committee, to put in parentheses, excluding the board president and vice president. And then on page 2, in the first paragraph, after the word investigator, in parentheses and quotations, to say who shall not be a CalPERS employee. Also on page 2, under B, formal investigation, the second paragraph, the should be capitalized, and consulting in the second line should just be consult.
If I may, Ms. Mather,
Yes.
on that one?
Yes.
The probably shouldn't be capitalized because it's a continuation of the sentence.
Oh, is it?
from-
Okay, then it
Right.
shouldn't be capitalized. Thank you for that.
Yeah.
Upon determining the formal investigation is warranted, yes, we'll leave that lowercase. And then on page 4 of 5, section 4, types of sanctions, to include in the list of sanctions, revocation of board member privileges, removal or suspension from a committee assignment, removal or suspension of committee leadership roles.
Maybe recusal from any proceedings with the
Well, and there was the question raised of whether recusal from proceedings where the victim is present, and I think Mr. Jacobs said that we needed to he needed to further think about that, but that also perhaps that could be addressed in the moment. We could figure that out. So those are the changes that I heard. Did I miss anything that you heard, Mr. Jacobs?
No, I think you got it.
Is that your? Thank you. The motion was made by Taylor and seconded by Hollinger. Any further discussion on the motion? Seeing none, all those in favor say aye. Aye. All opposed?
No.
Please note Ms. Brown's no. The motion passes. And now coming back to you, Mr. Fechner, you had something, if you could, thank you.
Thank you, Madam Chair. Part of the problem that we deal with here, and some of that goes to what Ms. Jepson said, is that we're trying to create policy while wearing handcuffs, because the legislature doesn't give you the opportunity to give us more options than what you currently have on the paper. So we're trying to craft something through a very narrow set of options to be able to deal with board behavior. No other group can discipline this board but the board itself. So at some point, we may need to look at legislative relief to be able to put more language in place to allow the board to effectively manage itself without having to fine-tune a set of guidelines that may not be appropriate for what we're trying to do.
Mm-hmm.
May not be sufficient. Thank you. Ms. Hollinger.
Yeah, and I just wanted to add on to what Mr. Fechner said and what the lady spoke to with trying to rush something through. We really were responding to the fact that the board doesn't currently have any rules or conduct in place regarding our conduct regarding sexual harassment. And so I think the effort to do this was to demonstrate that, to put in good governance procedures for ourselves. Well, I heard you say we don't want to rush it, but like Mr. Fechner said, we're limited in scope, yet we didn't want to not have something in place because I think that the time calls for it. But I appreciated your responses.
Thank you, Ms. Hollinger. Mr. Miller?
Yeah, I just wanted to acknowledge and express my appreciation for Mr. Fechner's comments, because I think in the bigger picture, as a new board member, I really was surprised to find out that on behalf of our members and the board, that as an elected board member, there is virtually nothing that can be done to address really egregious, even criminal behavior in terms of removing someone from that board. And even in the event that someone removes themselves by being thrown in jail, if they don't resign, my understanding is they sit out their term and their constituents won't necessarily have any voice on that board. So I think something legislative, something longer term, something more substantial to address those remote possibilities still would be wise, just for the credibility and the confidence of our members that there would be a mechanism to deal with bad behavior by their elected board members in the future.
Thank you, Mr. Miller. That brings us to agenda item number 7, which is summary of committee direction.
I think we have that. We just went through it.
All right, terrific. And then 7B is public comment. I have no further requests to speak, but is there anyone from the public who wishes to speak at this time? Seeing none, then we are adjourned. Thanks, everyone.
Okay, thank you.